Ridgewood Apartments versus Bonnie Morris. Miss Bonnie Morris is present in the courtroom and coming forward. And you have your representative on, Miss Casper, for Ridgewood.
I'm here, Joanna Asher.
Thank you, Miss Asher. All right. So, Miss Morris.
Yes.
All right. So this relates to the property at 79. There is allegations of material violations of the lease. So I'll just start by asking, are you are you trying to move out on your own at this time?
No.
All right. So I'll go ahead and start with some testimony.
Okay.
And understanding that, Ms. Casper, that there's no standard agreement offer available at this time, or is there?
I didn't understand that.
I said Ms. Casper.
Okay.
Okay.
Joanna, are you acceptable, willing to accept the standard agreement to move or vacate only? I recommend it.
Yes, the 7-day. Yes, ma'am.
Okay. But let me fully explain this to Ms. Morris. I'm not sure. I don't think she wants to take the offer, but I still want to make sure she understands. All right. So, Ms. Morris, there's an allegation relating to 79 that is not about failure to pay rent. This is where they're alleging that there is a violation of the lease, material noncompliance, breach of the lease for disturbing the peaceful and quiet enjoyment of the property, harassing management, threatening behavior, smearing dog feces on porches and walkways, entering other resident spaces. Those are listen to me.
I've heard these before.
Well, that's the first time you've heard them from me.
Yes, ma'am.
Okay. So those are the allegations. I can take testimony regarding those allegations. If I find the testimony to have sufficient evidence, I'll take testimony from you as well. You can cross-examine, but if I find that this is validated, then I will enter an eviction judgment. And that will give you 7 days to move out. If I find that it isn't validated, the case can be dismissed. But at this time, because you guys are not,
I didn't hear you.
at this time, I haven't finished, Ms. Morris.
Well, I can't hear you very well.
Well, do you like a hearing device?
Yeah.
Okay,
Thank you.
you're welcome. All right, can you hear me a little bit better now?
Yes, ma'am.
All right, now I'll still try to keep. So one of the options is to have your hearing. The other option is that you also can agree to move out on your own since since this relationship may have soiled, but that's probably not the right word.
It is.
And therefore you can move on to a new location. The case can be dismissed with no eviction judgment, but that option does only give you 1 week to move out by November 24th at 11 a.m. The case gets dismissed with no eviction judgment. But if they're waiving the right to have the hearing, you would waive the right to assert any of your defenses, your right to trial, and your right to appeal if you accept a standard agreement to move out only. So I just want you to understand all your options on the table. So knowing their options today, what would you like to do? Have your hearing today or accept a standard agreement to move?
Well, I have lots of documentation and many photos of what has happened to me while I've been there.
This is going to be strictly about these allegations only, because that is why they're asserting a material lease violation. I will keep it narrow to what they are asserting as an alleged breach. That means they want the alleged breach. And if I find that evidence, then you could be subjected to the eviction judgment with 7 days to move. That's what I'm saying.
I understand that.
Okay.
I am on Section 8 and I have been for 18 years.
That's a long time. Okay.
I have a perfect record. I'm in good standing with them. Can I finish?
Oh my God.
Yes.
And I've never been late on anything in my life.
And they're not saying you're late.
I realize that, but she has harassed me constantly.
We'll set it for a hearing at this time. It will take too much time. I can already tell. So Ms. Casper, do you have Monday at 1 o'clock available?
Do I?
No, Miss Casper first. And then I'll ask you.
Who are you talking to? Her?
Yeah,
Oh.
Miss Casper. That's why I try to.
Okay,
So
okay.
Miss Casper is the attorney for Ridgewood Apartments.
Yes, I know that.
Okay. So Miss Casper, do you have 1 o'clock available for a hearing?
On the 24th, Your Honor?
Yes, ma'am. I'm sorry.
Yes, I can make it happen.
Now, Miss Morris,
Mhm.
could you come back on next Monday at 1 o'clock for
Yes,
a
ma'am.
hearing?
Yes, ma'am.
Okay. At that time, because I think this will take more time than I can really give it right now to give it due justice.
Yes,
You have a lot of documents. You come back in person, November 24th at 1 o'clock.
Mhm.
I'll swear everybody in. We'll have a hearing
Mhm.
and we'll see how it goes from there.
Okay.
Understand that at the end of the hearing, if I find sufficient testimony that related to these specific alleged lease violations,
Mhm.
I will enter an eviction judgment, giving you 7 days to move out. If I don't find sufficient evidence or testimony, then the case would be dismissed because they haven't proven their case.
Can I?
And those are, yes, ma'am. But I'm not going to get into the hearing today
I understand.
because will take a little more time.
I understand.
But go ahead, Ms. Morris.
Will I be able to present my evidence?
Yes,
Okay,
at the hearing on Monday at 1 o'clock.
I will be there.
Okay. You've already stated that you are a Section 8 recipient.
Mhm.
I highly urge you to contact the Legal Aid Society.
I've already done that.
Well, okay.
This has already been dismissed.
It doesn't, every new case deserves new attention.
Okay, well, it was,
And if I'm telling you now also, I find it interesting that Legal Aid Society is not assisting you for I don't know the reasons. It could be lots of reasons, and I'm not going to speculate, okay?
yes, ma'am.
But let's just be ready on Monday to present your evidence.
Okay.
And then I'll hear their evidence,
Mhm.
and then it will be for me to decide.
Okay,
That's all.
Thank
Monday at 1 o'clock.
I'll be here.
Thank you.
Earphones.
Earphone. They don't work once you start leaving. Thank you.
Yep. Okay. Go. Will you hand me my screen box?
Now go. So we're on record in the Ridgewood apartment owners versus Bonnie Morris. I'll go ahead and swear everybody in so we can get that part. This is on for forcible detainer complaint. And so I believe it was a violation complaint. Correct. And so I'm gonna first hear testimony and hear from the plaintiff in this matter. Of course, pay attention, focus along, be ready to ask any cross-examining questions you may want to, Ms. Morris, okay? All right.
Joanna, the first thing I'm going to hand you is a document. Can you tell me if you're familiar with that and what it looks like?
Yes, this is our lease agreement signed by Bonnie as well as myself on April the 17th.
Okay. And I'm going to ask you to flip to the back. Can you read the first sentence of 39?
Community policies and rules, resident, occupant, and their guests shall comply with all policy and rules now or hereafter promulgating.
That's good. Promulgate it. And then read the first a couple lines of paragraph 40.
Resident shall cause all occupants, any guests, to show consideration for neighbors and not interfere with, disturb, or threaten the rights, comfort, health, safety, convenience, quiet enjoyment, and use of the community by the leaseor.
And can you skip down a couple lines to where it says item number 2? It's got the 2 little eyes.
Not engage in abusive, threatening, or harassing conduct toward leaseor or its employees, agents, or representatives.
Okay. And this is the lease you guys use in your standard course of business that you have residents
Correct.
sign on a regular basis. Your Honor, I'd like to enter that as our exhibit A if we can.
Any objection? It's a lease agreement.
No.
Thank you. I just want to be fully informed. Okay, thank
Okay.
you so much.
The next packet I'm going to hand you, can you explain to the court what these were? Are these are photographs?
Yes, these are photographs I've taken, where Bonnie has hung dog waste on my office door.
Okay, let's, do you remember when you took those? Or just, it was over a course of
It's,
a day?
yes, there's at least 9 of these, but there was other photos that I didn't, take or whatever, but if I leave my office door open, she throws them.
Okay, so these are pictures you took them with your phone?
I did.
Okay, and with that, Your Honor, I'd like to enter these as Exhibit B. They're just various photos.
A series of photos being proffered as Exhibit B. How many, and again, is that her, so you'll review, is that, do you have a courtesy copy for her?
Okay.
All right, so that's any objection, Ms. Morris?
I guess not.
Okay, so
All right.
entered, but again, we'll follow along with these. This is collective Exhibit B.
Yes. Joanne, what, the first picture, can you tell us what that purports to be?
She had actually left me a letter attached to one of the dog wastes. As long as Joe and Faith continue to leave their dog poop displayed on their door stoop, I will continue to bring it to you.
Okay,
I think it was dated 9/18.
all right, and so obviously this tenant has an issue. We just kind of frame it quickly for the court. What's the nature of the problem? Where's this, where's the dog waste coming from? How's it getting from wherever it's being?
Initially, she was arguing with the residents that are catacornered to her. They actually ended up picking up dog waste. I believe Bonnie has been taking it out of the urn that's on their porch.
So what's their position? So the dog uses the bathroom, they pick it up. What do they do with it?
They put it in an urn on their patio.
No. You'll have the full opportunity
Okay.
to cross-examine, but
Understand.
please, but remember, just don't interrupt us. You might want to write your notes down on where you want to cross-examine. Thank you.
Okay. So if you flip through your packet there, of the pictures. So is it your testimony that each one of these bags has been taken by the tenant off of the neighbor's patio
Patio, yes.
and moved around and put on?
Yes.
Okay.
Right.
All right. That's all the questions I have for those documents.
Okay.
This next group, you can just lay it aside in case Bonnie has questions. Do you recognize this letter, and the documents behind it that I'm showing?
Yes.
Okay, what is the first document?
It's a 14-day notice, lease violation.
And what date did you send that?
This one is June 25th.
Okay, and and what are the other things that are behind the letter?
Uh,
Not specifically, but
She's
just,
got various lease violations, one, dated all the way from 5/30 all the way up to,
and these were made in the regular course of business. This is just part of what you do as
yes,
property
they're all done by me.
Okay. And with that, Your Honor, I'd like to submit these documents.
Any objection to these notices? Ms. Morris, any objection to these notices? We're good. We can get into the substance of them. I'm not, when you cross them, but do you have an objection to them being tendered as evidence? That's all.
Well, can't she do what she wants?
Who?
Joanna.
Miss Asher is she's testifying about them.
Okay.
So she can testify about them, but technically I should ask if you have any objection to the entry of the letters as evidence. Again,
I don't know what you're saying.
okay, so this is the thing. They're being offered as evidence.
From her. From her. Okay.
Her attorney has proffered them as evidence that they will use for their case.
Okay.
And so as long as, and it's simple, I don't expect you to have an objection. They've been
No, I don't.
offered properly. Okay. Thank you so much. All right. So this is collected Exhibit C.
Okay. This is the 14-day letter that's in front of you. What does I guess that's the third paragraph. What does it say?
Harassing conduct conduct toward management, verbal attacks, threatening behavior, refusing to leave the office when asked, harassing other residents, smearing dog feces on porches and walkways, and entering other residents' lease space uninvited.
Would that entering the lease space uninvited, would that include the neighbor's patio area?
Yes,
Okay. Have the police ever been called regarding these incidents?
yes.
And what was the result of that?
Just a good conversation. They usually try to calm Bonnie down and have
Was
her.
she ever arrested?
Yes.
Your Honor, can I ask the court a question?
Sure.
Can you take judicial notice of court net, like of arrests, citations that have been filed?
I can or will I? But you would, if you wanted to tender that in a document that you've already printed out the court net and she knows specifically about it.
Well, she can, I think, yes, I have it printed out, but do you want to look at it?
No, I just think if you're asking her questions, then I'll go from there whether or not, but I don't think I
She's
want
listed
to.
as a victim, she's listed as a victim one in the police report.
Correct.
So I thought I could ask her questions about it, but
I think that, and again, and for purposes of whether or not I need to use that, I mean, I could take judicial notice that there is a criminal activity pending. And it'll be the same questioning that you would probably ask her about it. I understand that just might bolster the veracity of her testimony.
Yes, ma'am.
But I'll handle that, but I think I understand. I would not question that if you have, as an officer of the court, if you have the printout of a court net relates to citation that you're gonna get testimony from your representative about.
if you
Alright.
wanted to copy out,
And
you can have.
I think, thank you.
So what I wanted to question you about, Joanne, was the night that she was arrested. Just briefly say what happened.
That would have been the night that I don't know what was going on in the community. She was in an argument and
You live on property, is
I
that
do,
correct?
yes,
Okay.
I'm right next door to my office. The police were called and like I said, they thought they had her calmed down inside of her apartment, but she came back out. And she came to my door and was banging on my door. I called my maintenance tech that also lives on the property and he came out. I don't know if Bonnie realized that the policeman was still there. And when she walked over to talk to Chad, my maintenance tech, she shoved him. And that's the night she got arrested.
Mhm. In this report I'm looking at, it says that she, and this is in quotations, I'm going to punch your teeth in. Is that
She didn't say that to me. She said that to another resident.
okay? And it's also in quotations that she was going to shove poop down your throat. Is that,
Yes,
pardon?
yes.
Can we clarify who she said what to and what she heard?
The first
Thank you, I'm so
was
sorry.
victim identified as victim number 4, Jennifer Luby, I'm assuming is a resident.
Correct,
So that was the punch you in the teeth comment.
correct.
And then the other one looks like it was off to victim number 2, who is identified as Joseph Rock.
Correct.
Okay, thank you for clarity of the court. Just want to follow along with the testimony.
Was there any physical altercation? Did she throw anything or did anybody get hit or shoved?
To my knowledge, she's hit 2 other residents on my property.
What do you know of it? Tell me what you know about that.
Joe, she slapped. He's the one that she argues with about the dog
Is that
waste.
the Joe that's referred to in that
Uh-huh.
letter? Okay.
She slapped him and then Jennifer, she got into it with her because Jennifer records her and she slapped her.
How many times would you estimate, if you can, would you estimate the police have been called for this one resident?
Some of the folks, and I don't always see it because I'm in the front, they're in the back, but some of my residents have told me it's been like 28 times.
And she moved in April?
She did.
April of what year? April of what year?
Oh, I'm sorry, 2025.
Thank you.
I think that's all the questions I have, Your Honor.
All right, so Ms. Morris,
Mhm.
this is your opportunity to cross-examine Ms. Asher.
I can ask her questions?
Yep, yeah, you ask it in a way that you're trying to get, you want to get your evidence out, your testimonial evidence from Ms. Morris relating to these allegations that you've had these lease violations, and that's why they're trying to evict you.
Understand.
Okay.
I haven't hit anybody or shoved anybody.
So, and again, it's like you want to ask her in a form of a question. And I will give you an opportunity at the end to kind of give your own testimony and
Okay.
kind of like summary.
Okay.
Okay, so if you have any questions, this is
They
when
go
you
ahead.
ask Ms. Asher
Okay.
in the form of a question.
Did you know about the incident on July 24th, which was when I cut the stuff down and Joe threw it all back on my porch? Did you know about that? I told you about it.
I'm sure. Yeah, it was, you cut some weeds down or something.
Yeah.
Okay.
And I went inside to change my shoes and I came back out and there's a sidewalk that runs between his building and my building. He was sitting at the end of the sidewalk with his phone propped up on his steering wheel. I walked down there and I asked him if he had thrown the stuff onto my apartment. He jerked the door open. He came out and I was walking backwards and he kept saying, "Hit me, hit me, hit me." I did not hit him. I reached over with my index finger and I touched him on the nose and I went back to my apartment.
Do you have a question for her related to that rendition?
Did you know about that?
Yes, that's the day that I was told that you hit him.
By Jennifer.
Several people.
Okay.
Okay.
There was nobody out there. And if Jennifer was out there, she was around the corner.
All right, so are you saying that, so I know you've had, your question is, did anyone else see this incident?
Did anyone else see this incident?
Sorry. I didn't, but thank you for the lead.
Yes,
Well, who would that be?
That's fine.
tell her.
You can tell me.
Ella was standing inside of her living room window.
Who was?
She said Ella,
Who?
a lady named Ella. That's her answer?
Yes.
That's her
Ella-
answer to you. So
Ella?
now you can ask her an additional question,
Okay.
or you can, yeah.
Has Ella been to you and complained about me?
Yes.
Over what?
You were on her patio one night banging on door to window. Just, she actually recorded you demanding, it was late at night, demanding that she give you your things back.
Right. That did happen.
Yes, she,
Okay. Okay.
So I want to know what this vandalism charge is. I've looked it up and vandalism is when you destroy property.
Do you have,
What have I destroyed?
Who said anything about vandalism?
right,
it's in there. Yes, she did my door. I have a photo of it where she bam, 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 and it's got a dent or my painting. Yes.
okay, so that's part of it, but I do think she's also testified earlier about some other things that relate to also the allegations as they're enumerated on the lease.
I've been arrested twice.
Okay, so this is the other thing. As you're asking questions, you have a right to remain silent as to any allegations related to criminal activity and to protect yourself on that. And again, also, so testimony that you want to give, again, we're going to ask that in summary related to the violations in the lease. And so again, just be cognizant of your admissions on the record.
I'm not sure I understand what you're saying.
I think I've said it kind of clearly for the record
Mhm.
and again, just doing my due diligence that this is evictions court. So we're only here about possession of the property and whether or not they meet the grounds for the violations that they allege. They did open the door to a criminal activity complaint, you can ask questions. It's kind of in the purview of what they've already put on the record. But I do not need to hear about, other possible criminal activity that won't be relevant. And I just want you to understand that you do not have to put that into the record. As opposed to, because this is not the criminal court action,
Okay.
and I
I've
want
been
to
a-
save you from potentially any incrimination.
I've been assaulted twice on the property.
So you can ask, again, they are now bringing a case
Okay.
against you.
Did you know that Joe pushed me down onto the concrete?
Irrelevant.
For purposes of, the objection is that it isn't relevant to the reasons they have gave that they are basing the eviction on. So to the extent another resident may have been involved in an altercation with you, to the extent it has to be a defense to what they're bringing against you, I'll allow it. But if she's saying that you got into an incident with another resident, that someone pushed you, I'm going to sustain that as not relevant to this particular case.
What about the man that came out of your apartment and beat me up?
Didn't happen.
Okay, well,
That's her answer.
thank you.
I have,
Now,
I have photographs.
you'll have to make sure that you're ready to link them to whether or not that survives. That's going to be enough to say the allegations they have brought about what they allege you have done.
Mm-hmm. They meaning her or what the neighbors have done?
No. So this case is the apartment complex, the apartment complex versus you
I
in
understand.
an eviction case.
I understand
So
that.
they have to prove to the court that you have violated that you have allegedly violated. Well, they have to prove, according to the sections that they have presented to the court, that your alleged behavior is in violation, and that because they've given you certain notices and opportunity, that you continue to act accordingly. And then based on that, and based on any questions you say that negate that or refute that or say these allegations
What was the
didn't
word
happen.
you used? Rebuke or rebuke?
Refute. That you refute.
Okay, because
Yeah.
Jennifer used the word rebuked.
Rebut is another way, but basically you're gonna say, I deny these allegations based on XYZ. And I need proof. And that could be either your testimony, you have proof, because in the end, I'm the judge that's gonna weigh both of your evidence, whether it's by testimony or by documentation or in a blend.
Well, the night that the man beat me up, EMS came and so did the police, and they took pictures.
So I'm sorry.
Rejection.
So the objection is that is not relevant. Listen, Ms. Morris, and I do. I think you've heard. We all try to give leeway when we sit here, but it's not relevant to the line of questioning that Ms. Casper, the attorney, has already elicited from Ms. Asher. So when she objects that it's not relevant to what they need to prove in an eviction case, I agree with her, and so I sustain that and say that you'll need to move on from this alleged incident where you may have been assaulted, but it's
Twice.
just not right. And I'm not here to question the question of veracity of whether or not you were assaulted. Okay, because those will also be potential criminal activity, but that's not what they're saying is the reason why they're asking
So
the
what
court
is
to
the
evict you.
reason? What is the reason for my eviction?
As that's a question to Ms. Asher, she may be able to give you another summary of it. So is that your question to Ms. Asher at this time?
Yes, I guess.
Okay, so the question on the floor is to Ms. Asher is, why is Ms. Morris being evicted?
The disturbing peaceful, quiet enjoyment of the property, harassing management, threatening behavior, smearing dog feces on porches and walkways, entering other residents' spaces uninvited.
Did you know about the 20 bags of dog poop on his patio?
You can answer that. I don't think it's, first of all, when you're saying he, could you refer the court, who is he?
Pardon me?
Who is he?
Joe.
Okay, so do you know that there is 20 bags of dog poop on Joe's patio?
There was. This was early on.
Okay.
I picked
So,
up.
no. Okay. Do you want,
Objection. I mean,
I think it's gonna want objection. Technically, I do think it could be relevant because some of the testimony is
but
where
not
this
in her
dog.
favor. She's
I
arguing our
agree.
case.
I agree. You know, Ms. Casper, thank you. The court needs you to understand that when I'm already believing that you may say something that's not in your best interest.
All I can do is tell you what I saw and what happened.
And
And I have plenty of documentation about it.
why don't, okay. Because I'm just gonna cut across the field a little bit. If you're here to tell me that, and again, let's just say speculation, that you knew this dog poop was on somebody's porch, you went onto that porch and you're saying this is why this is in violation, then certain admissions might come out that you in fact did go on somebody else's property in violation of the
Because it
lease. In
stunk.
violation of the lease. And if that's one of the reasons that you're gonna give is just because you didn't like the smell. But then I go back and I say, does that match up with one of the violations, entering other resident spaces when you're not allowed to, because you're not maintenance, because that's not what you're tasked with? And then the evidence says that this is exactly where those bags come from, that's not in your favor.
I put them on his porch so he could see because she wouldn't address the issue.
Let me ask one other thing
Okay.
of Miss Casper. Though I know we could get to the end of this hearing. Is there any opportunity for Miss Morris to move?
Your Honor,
It might not be.
one thing I wanted to point out, do you remember from last week, you asked her if she had legal assistance?
Yes.
Okay. Yeah. But yes, I think for all of these people involved, Joanne included, Ms. Morris included, people need to separate. So we are willing to, are you getting at the standard agreement?
I am.
Mhm.
So Miss Morris, let me understand. Let me try to explain to you what I'm tasked with.
Okay.
I'm tasked with taking the eviction complaint on its face, the four corners of the documents. And that's where the violation is, the forcible detainment complaint. Do you have that in your records? Or you got that note? And it specifically says.
Is that where she listed the charges?
She listed the violations of the
Okay,
lease.
okay.
Because I don't want you to like criminal court, we say charges. Here we say lease violations. Now, lease violation could be a criminal charge, but that's not what we're presented with.
Okay,
Well,
okay.
technically not. But so I'm looking at these outlined things, okay? These outlined things on this. And then based on the testimony and the evidence presented, I say, yes, I agree that you're in breach of this lease. And if I say yes, at the end of the hearing, I enter an eviction judgment and you have 7 days to move out. Okay? That's just how this court goes. I'm not trying to disadvantage you, but that is the process here.
Okay. Can I talk?
Yes, ma'am.
Okay. I was in a motel for 5.5 months before I found this place.
Yes, ma'am.
I am on Section 8.
Yes,
Have been
ma'am.
on Section 8 for 18 years.
I remember you said
And I
that.
have a perfect record. Perfect.
I understand what you're saying.
And I've never been late on a bill in my life.
And luckily this is not, I'm sorry, let me go ahead. I don't keep interrupting you.
All I know is it's still happening. It was out there this morning.
The
Stop
poop on
it.
someone else's residence?
Hmm?
In somebody else's residential
It was in a
apartment?
bag.
On their porch?
Okay. No, on their stoop.
Okay, in their
Okay,
property,
okay.
on their space.
He went out and bought a little trash can,
Sure,
flip top, and a poopy scooper.
which he can do on his property.
Well, I have to look at it.
That's not a
There's
violation.
nobody else in that whole community that doesn't pick up their dog poop except the aisle behind where,
That's not okay, understand. That's, if they want to bring violations against those tenants, that's.
why
between-
didn't she?
She doesn't have to tell me that today. That's not the case before me today. The case before me today is Ridge Apartments versus Bonnie Morris.
Mhm.
And I'm gonna tell you now, based on everything I've already heard, standard agreement is available for 1 week. If one of the things, I understand it is not ideal, but I want you to understand that we get to the end of this hearing and I find in their favor, I sign an order giving you 7 days to move out. If I hear that, if I believe that you have harassed her because you don't feel like she is doing everything the way you want her to do and taking care of these residents the way you would think that she needs to
I
take
would-
care, that if I consider that harassment, that's one check in her favor. If I say entering other residences prove that there's poop on their porch, that you're now hanging on the door with your letter saying
I
that
have
you've
one.
done it,
I
then
have.
that's in violation of the lease. If I say yes, check 2, then we're on our way to an eviction judgment not in your favor, giving you 7 days to move out, and that eviction judgment goes on your record.
Well,
Okay,
that-
so this is the other thing. That's one option that we can continue down that path. But I've already asked if a standard agreement offer is available to you.
What does that mean?
I'm gonna explain that now.
Okay.
Okay. Usually is, instead of having the hearing, which we now are in, the court will pass the case 1 week to give you additional time to go ahead and vacate on your own, have the case dismissed once we come back and find that you've moved out, and so you don't have an eviction judgment on your record.
I understand what you said, but I have not been given the opportunity to say what all is wrong in the apartment.
That's not what the basis of the eviction is for. The basis of the eviction is for material noncompliance for disturbing peaceful enjoyment of property.
I have argued
It is-
with him constantly.
That's an admission. that
Then
you-
why doesn't he pick up his
First of
dog
all,
poop?
Let me tell you this. Don't yell at me. Miss Morris, please don't yell at me.
I have not
Okay.
lied.
I don't think you're lying, but you're not helping yourself. And if anything, the demeanor in which you're presenting yourself today, the temper, the anger,
It's showing.
why do I think you would act differently at your apartment complex?
What would you do if this was happening next door to you? Would you complain?
I don't have to answer that. That would be extremely speculative, but I can tell you what I won't do. I won't go and get that dog poop off somebody else and hang it on someone's door. I can guarantee you that I would not.
She didn't address the issue.
I understand, but I would not.
That's why I took it down there.
Do you want to accept the
don't
standard
raise your voice,
agreement?
yeah.
Yeah, and please, and also don't point. It's very disrespectful and it lacks decorum for the court. And I am due that type of respect.
I'm sorry.
Okay,
I apologize.
thank you. So what is offered to you today? And I think you need to take a quick moment to yourself to think about it. Instead of completing the full hearing today, where I continue to take testimony and look at evidence related to whether or not you violated the lease. And if I say yes, and I enter that eviction judgment, you have 7 days to move out.
I have
The
no,
other option on the table, and I understand you've been in hardships before, is that you take a standard agreement to move out on your own. You avoid an eviction judgment going on your record. You move out on your own in 7 days.
okay.
And then let me just fully tell you what's on the table, because they don't have to do this either, being that we're already in the hearing. We're saying we're stopping the hearing. I want to go ahead and say, Ms. Morris, you still have 7 days to move out on your own. Take all your belongings and turn the keys. We will come back and dismiss the case, Your Honor. Keep that eviction judgment off your record. Allow you to still seek Section 8 at a new location, albeit you had a hard time getting into this one, but you at least do understand that
If
that
you-
option's on the table.
If you do not complete the first year of your lease, when you're on Section 8, you have to wait a year to reapply. So,
But-
and I don't have anywhere to go. I have no living family members. I have no children. I've never been married.
Yes, ma'am. I understand it is not an ideal situation. I'm just telling you the options that you're being presented with today. I am so sorry, Ms. Morris. It does not seem like this was a good fit for you,
No, it certainly wasn't.
but that is where we're at this time.
Well, I didn't want to move there in the first place.
So for purposes of the hearing today, I do give you this opportunity to tell me what you would like to do. Would you like to continue completion of the hearing where I could possibly render a judgment against you and enter the eviction judgment, giving you 7 days to move? Or would you like to take a standard agreement to vacate on your own and have no
So
eviction
you're
judgment?
evicting me.
I have not completed the hearing,
Okay.
but I will allow the hearing to continue. And in the end, render a judgment one way or the other. Either I'll grant a dismissal because I feel like they have not satisfied their burden.
It's been dismissed once.
Okay, so let me tell you, I could,
Okay.
I have the papers.
well, okay, again, even if there was some other separate case, I find that not relevant today. Okay? Because I have to look at this with fresh eyes. I have to look at it from like tabula rasa, blank slate from today. Okay? And that's what I'm tasked with. Different judges even sit in these chairs and I can't understand. I won't always say the thinking of that judge and why they did something. Okay? But today I look at this as in fresh eyes. So if I get to the end of the hearing, if that's the option you're choosing,
You told me I shouldn't say anything else.
no, I'm telling you, I can continue the hearing. I can continue letting you question Miss Asher,
No.
okay? But then I would not be doing this, and I'm probably even overstepping my little discretionary, because I did not think it was in your better interest to consider these two options at this time. Would you like to take a moment in the hallway and think about it?
Sure.
And you can even talk with, okay, take a moment, leave those right there with you. Take a moment, we'll just take a quick recess. And you can really think about your options here, okay? You can take that with you. She can take her paperwork. Okay, yeah, you don't have, yeah, I'm just saying, you don't, maybe you just kind of talk about it. And if you could, thank you for allowing this brief recess. You have a question?
Nice, yeah, just so I understand.
Sure.
Your two options. I understand the first one, if we go further. Second option is that she has to vacate the property 7 days.
And then we dismiss them when we come back for review with no eviction judgment.
But it's 7 days with all we would be allowed over the weekend and all this action.
Because what's the review date? Is there any leeway for 10 days? It's up, and again, I'm not trying to, I do understand
With
it's a
certain
holiday.
conditions that the behavior comes down during, whatever the period we decide, even the 7 days during the standard review that, she not
Okay.
continue doing these things.
We'll talk about that when she's back fully on the record, that it could be, that there's some potential that it could be extended 7 days, maybe to 10. Thank you.
Thank you.
You're welcome.
I don't want to lose my Section 8.
Yes, ma'am.
So I'm going to take, but will I ever have the opportunity to speak about what happened at her apartment?
The thing is, if those opportunities present themselves as separate and distinct from this eviction, you can't. But that's the tribunal in which you would handle that. I say the other court. If you felt like, and again, I want you to understand that this is only about this case and the very limited things that they have brought up and whether or not you have violated those limited things. Now, I understand that if there is a criminal action still pending, I didn't get further into that. I know you talk about that in defense to your any criminal place, or you can tell the police officers your own criminal allegations. That is different and distinct. That is separate and distinct. It's the same way I tell people civil violations, like a civil case is separate. So in your case, it's not a failure to pay, right? But some people come in here with failure to pay. And just because they set standard agreement, I tell them that does not alleviate you of your responsibility to pay, and they could bring a civil action. So those things are separate and distinct from today. The thing is, what you have to tell me, do I think it will save your eviction case?
If I get an eviction, I can't move on Section 8.
And I think that's one of the reasons why,
Okay.
so
I cannot, there's no way I can possibly pack my things in 7 days. I have advanced osteoarthritis. I have degenerative joint disease, and I was just diagnosed about 6 weeks ago with spinal stenosis. When
Well,
you don't want to hear this?
I'm sympathetic to what you said. I see people in worse conditions than you.
Do what?
I see people in worse conditions than you have to take the standard agreement. Now, we could always say if there's community partners that could help. I don't know if I could connect you with those. You can always try to go to stopmyeviction.org. I think there's a pamphlet, but that does not, so one of the things is my understanding is the authority is for 7 days.
7 days.
So she doesn't have authority to give you more than 7 days. Yes,
There's something going on with the other court.
separate and distinct.
Okay, but she's gonna have something come down that says she has to do something until December the 4th. Before it comes back.
Those are the criminal charges.
That they're completely separate and distinct, and I don't mind openly
But I
talking
mean,
to you about it.
okay, if she's like on.
So let's say let's say, and I'm gonna be speculative on the charges. As long as you do X, Y, and Z, they can dismiss the case.
Right.
But that won't keep them from dismissing it. What we're doing here
I
today.
understand, but what came about today, it's like house restriction. Okay,
I'm just being lenient here. That is that judge's restrictions that they put related to their case. It could be such as that, you understand that you're not allowed to go this way or that way, or else you'll be in violation of the court's no contact order.
Yeah,
That's a bond decision in a criminal case. The
Yeah.
two can coexist
right.
at the same time.
But if it says that she has to do this until the 4th,
Sure.
how does she do it to the 4th when she doesn't have a plate?
It will, then you go back to the court and say, I didn't meet those obligations because I was no longer there.
Okay,
Because they are separate and distinct.
so,
And that probably is all relevant to the criminal action.
yeah, so she needs, and she didn't have she was gonna have to drive home and get her release agreement. Could somebody make her a copy? Because she has to go there to the bail, I guess, and give the bail. She has to give the lease a copy to prove that she lives in that apartment. Add that to the jail.
You said she had a copy, but there's.
Oh, there's a courtesy copy right
I
there.
have that.
Okay, thank you.
Well, you did.
Okay, that let me just tell you, everything I probably can do an educated guess about what you're trying to tell me about, but it won't. The thing is, they're separate and distinct. So, are you supposed to be on home incarceration program?
Pardon me?
Is it supposed to be HIP?
That's what they said, yes.
Yeah.
They will
She's
have
got
to
a
correct.
card. I'm sorry.
They will have to correct that till the end of the termination of the lease. So even though it may be till the 4th,
She has a card with her date.
I know, I got it, but that's not for me to fully take into consideration. She has the lease at this time. That's all I can tell you. She has her lease at this time. Okay? Do you have an attorney on your criminal matter?
Yes.
Do you have an attorney from the public defender's office?
Yes.
Contact him or her immediately.
I was just in court.
I know, but leave them a
Okay.
message. I figured you would be. I figured that you would have an attorney from the public defender's office. Contact them as soon as you leave here, okay? They may be able to, and again, I'm not going to say if they can or cannot.
They don't handle evictions.
No, they may be able to ask for a bond modification based on your circumstances. Which means, when I say bond modification, they may be able to ask for something, a more lenient bond. I don't know, but tell them those are the words that you need to ask your public defender based on you taking this standard agreement to be out. But what's my 1 week date, by the way?
12/1.
By December 1st. Because you're taking this, explain that to them and they may be able to present to the court a bond modification. Okay? Of where else you may go. Okay? So thank you for asking those questions. But for today, for clarity of the record, what's being presented to you is a standard agreement to vacate by December 1st and the review date is 11 a.m. Understand that this is a negotiation. This is like, in doing so, only for this eviction case, you waive your right to assert offenses for the eviction case, and your right to appeal just the eviction case. It does not close the door from you in trying to, if you felt like you had another matter that you would bring up from the foundation up, but it would not relate to this eviction. Like, not for whether or not to grant an eviction. If you feel like you have defenses to allegations of
Well, the
an
police
assault
made a report
for the criminal action,
on the night that he beat me up.
then you should make sure that you follow up with on that. Don't miss conversations and phone calls from the police. It is just completely separate and distinct from the eviction case. So for purposes of today, I do need to know if you're willing to accept the standard agreement. I understand that it's going to be a tall task for you to get out on the 1st, but that's what's been presented to you at this time. If you're not, and this is again, you accept the standard agreement and you fail to move out by December 1st at 11 a.m., then they do get an eviction judgment. And the eviction judgment is with immediate possession. Okay? Listen to me. If they come back and ask for the eviction judgment and they get the eviction judgment, this apartment complex,
Okay.
them and their attorney. That's why I say they. The attorney and the attorney's client, the apartment complex. She's the representative for the apartment complex who came to give testimony. Okay. Now, if we come back on December 1st at 11 a.m. and you have not vacated, they do get an eviction judgment that day. The eviction judgment that day is called with immediate possession, which means they have the authority to get an eviction warrant from the court. They have to get that eviction warrant from the court, and then they have to take that warrant and contact the sheriff's office. This does not happen in a day or two. They can even say, I understand you're still getting out. We'll wait until we get the sheriff involved to give you time to get out. They don't have to do that at all. They may, because it's additional cost for them to get the sheriffs involved. And they don't want that cost, but they will do it. But in the meantime, if you're getting out fast, then you can ask them. They don't have to do it. If the eviction judgment was entered, is there any way we can set it aside because I did move? I'm not saying they will, but I want you to know that it's not just that you stay because you can't get out in 7 days. And if you don't, then they'll get the eviction judgment. But that's an offer they're presenting to you. You would need to try to work with community partners and things like that and move out in the 7 days. It's not ideal, but it's not ideal for most people in your position. Yes, sir.
We're as research on community partners, but
Excuse me?
Speak to you out in the hallway after you.
community.
So for community partners, this is an eviction court diversion specialist. She knows some of the community partners that she could put you in touch with. She's not an attorney, she doesn't give legal advice, but she does have knowledge of who community partners, some that may be available.
Oh, I was on the wrong thing. I thought community partners came somewhere where you could get help to move and all.
That's what I thought.
They may, but they don't, it depends again, these are often volunteers, they're community,
Right.
like, grants and funding, but she knows she can connect
She
you.
can help. Okay, thank you.
And again, I just don't want to sell you false hope,
No.
but that's the best that we can give to you today, is to still try to connect you with those. So for purposes of the day, Ms. Morris, would you like to take the standard agreement to vacate and doing so by December 1st at 11 a.m.?
Okay. Do I need to get the police reports from what happened that night?
That is completely irrelevant to the eviction judgment. You can
Okay.
always get the police reports. You have an action pending. You'll have your full opportunity to defend yourself and maybe exonerate yourself in the criminal action or come up with a separate resolution. They could be they could say, Ms. Morris, as long as you don't have any future violations in 6 months, we'll dismiss it. They can say, ma'am, you're on probation. As long as you don't have anything, For 2 years, it'll dismiss. There's I mean, I could go into all types of speculations, but I don't know how the criminal action pans out. But that is definitely where you get to assert your defenses to the criminal action. You speak up, you testify, you can take it to trial. You can have a jury of your peers in the criminal action if you so choose. That's just separate and distinct from today. And so for purposes of today, would you like to take the standard agreement that we have talked about in depth?
Yes.
All right, thank you so much. I'm noting that you're accepting the standard agreement to vacate by December 12th at 1:00. December 12th at 11 a.m. The deputy,
Say that again.
December 1st at 11 a.m. That's what's on your yellow
That's
card.
Monday.
Yes, ma'am. It's 1 week. And as long as you're moved out, we come back, the case gets dismissed with no eviction judgment. Will help you in your future tenancies, and it'll definitely help you with Section 8 in the future. So that part can remain impeccable, okay?
What you saying is, when you get out by the first, if your Section 8 is not
Effective.
affected,
Okay.
correct?
Yes, sir. But thank you. And I wish you the best in your new location, okay? Eventually, and I know it may take some time, but good luck with everything. All right, and I also want to thank Ms. Casper and Ms. Asher for still extending this resolution to you. It's a negotiated settlement, so they did not have to do that, and I think this is showing that I think the parties are just ready to go their separate ways, okay? Good luck, ma'am. That concludes the hearing for today.
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. We're going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
No, no, trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.